Welcome to On Writing with Onkarabile, a show that aims to promote reading and writing in the communities. We seek to restore pride and dignity of Africans through the power of reading and writing. Ladies and gentlemen, my name is Onkarabile Mokoto and I am your host. Kindly don't forget to subscribe, to share online as we are embarking on a very inspirational conversation today with our esteemed guest, Advocate Ntombifuthi Mpofu. Thank you so much for coming to the show.
You're welcome, sir.
Thank you so much. I see you have done a lot, in your field. But I want us today to focus on the issue that is very rare when it comes to black society, the issue of drafting a will. We have seen an argument, we have seen a battle between families, relatives, kids, siblings, when it comes to the issue of assets, sharing of assets, especially if someone, maybe parents are deceased or a family member is deceased. So I want us to talk about that, but firstly, let's just start by maybe explaining to our audience, what is a will? When you talk about a will, what are you talking about?
Okay, it's very important to have a document called a will. A will is a legal document that describes how you would like your property or other assets to be distributed after your death or your passing.
Okay.
So this document can be either written or typed. As I was preparing for the interview, I went through my old notes. I picked up that it is not allowed that you will record your will. You cannot do that.
Okay.
So you must write it. It must be written on a piece of paper, or it must be drafted on a piece of paper.
Any reason for that?
I'm not sure of the reason why it must not be recorded. But the requirements of having a valid will is that the person that is writing a will, we call that person a testator. So the person that is writing a will must actually sign the will.
Okay.
And if the person is signing the will the person signing a will, he must be or she must be in the presence of two witnesses. So the recording part does not form part of the requirement, because the will has requirements.
Okay.
Right.
Okay.
So if this will now, it gets drafted by a testator, and if it's one piece, if it is a one-page document, one-page will, so it means the testator must sign and the two competent witnesses must sign. Very important that the person that is signing a will must be actually 16 years or older at the time of drafting the will.
Okay.
And the witnesses who are part of the signing of the will must be actually at the age of 14 and above. Then you can witness a will. But if the person is younger than 14, then your will will then be invalid.
Okay. I was not sure about the part of two witnesses, because I always watch one of these shows that talks about the housing and stuff, buying of houses and stuff. And a lot of times you will see that people have left what you call a will, maybe to a grandchild instead of a child. But I've never heard when you talk about signing. So who must sign? Like, is it the family member, or who must sign? Like those two witnesses? Isn't it that a will is my personal? I have to write it privately, alone, choosing if I leave it to you or Noluthando, So who must be those witnesses?
Okay, fine. So the competent witness, it could be anybody, but it's very important that that person that you choose must be at the age of 14, at the age of 14. And the person that is witnessing the signing of the will, right? You cannot be a witness and benefit in the will.
Okay.
So when you are part and parcel of the drafting of the will, that alone, it disinherits you. So once, let's say, for example, you draft a will, you say, I want to leave my car to Ntombi. When you say you want to leave the car with me, then you then call me to come and witness it. There's an element of maybe you didn't do it willingly. Maybe I force you to give the car to me.
Yes.
So now that then disqualifies me. So, but it can be anybody. It can be your family member. It can be your children. It can be whoever. But the person that is witnessing the will must not be the person that's going to benefit.
Okay.
So,
I want us to go back to the recording part, right? So I want to put the question like this.
yeah.
Now, what if I'm in a state of unable to write?
Okay.
Can I tell someone
Yeah.
and then that person is writing what I'm saying, but maybe I sign, because obviously signature is going to need me to sign, right?
Okay.
So can I tell you, like sort of, let's say you're doing affidavit, then you go to police station, then, sometimes the police will write for you.
Yeah.
Can we do the will like that, whereby I don't write, but I tell you what to write there?
Okay. So if there is a situation like that where a testator is not able to write a will, previously the testator will be required to put a thumb on to make a mark or a thumb in their will, but the will must be written. So if you instruct somebody to write your will on your behalf, then we need a person called a commissioner of oaths.
Okay.
Right? So there will be a commissioner of oaths, there will be your two competent witness, and there will be you as a testator. So what is the job of a commissioner of oaths? It's to make sure, is to confirm that this person that is drafting a will, actually it is the person that says, I am the testator. So the person will then confirm to say, I am confirming that Onkarabile is the one that is giving the instructions to Ntombi to write on his behalf. And then you put your thumb, and then the commissioner of oaths will then stamp it to confirm that indeed these are the wishes of Onkarabile. If Onkarabile passes on, then we can consider this thing as a will.
Okay. No, well said, well said. Now, okay, I'm drafting a will.
Yes.
I'm saying Ntombifuthi and Noluthando will get this.
Yes.
And then I don't mention other people because that's my choice, right?
Yes, yes, yes. Of
But
course.
then after I pass on, Noluthando and Ntombifuthi are excited. While they are on their way to share their assets, someone comes and say, I'm going to fight this will.
Yeah.
What is the importance of the will being contested, whereas I am the one who chose? I did not include that person. Why must now the will be contested to a point where that person can be included, whereas that person was not there when I was writing the will?
Okay, firstly, if there is a will, right? A will is a powerful document. And it's very, very important for people to draft wills, because what it does, the will actually, it expresses your wishes, how you want your things to be divided and how you want your estate to be divided. So if you have chosen Ntombi and Noluthando to be on the will, those people will benefit. The third person that comes and says, I want to be included in the will, that person, by just virtue of coming and saying, I want to be part of the will, that person will not be automatically included in the will. It doesn't work like that.
But they can contest the will.
They can contest the will, but how it happens is that when, let's say, for example, you have left your will. You left your will. Maybe you left your will with your lawyer, or you left your will with your pastor or your counselor or whoever that you trust, and you left your will, and then you passed on. When you pass on, and then this person that is aware that Onkarabile left a will behind will then come forth and say, listen, there is a will in place. Right? And then that will have to be taken to the master of the High Court. Then the master of the High Court will then take this will and look at this will and confirm that this is a valid will. So remember, in the beginning we spoke about the requirements of the will, that it must be signed in the presence of two witnesses, right? And if the master of the High Court is satisfied that you have written it proper and it meets all the requirements of the will, and then the master will accept it as valid. So if X comes and says Ntombi and Onkarabile must not benefit out of the will, that person will not be included.
Okay. Now I want to make a practical example.
Yeah.
You have, maybe let's say in your marriage,
Yeah.
right? I have an outside kid, not in marriage.
Yeah.
But then when I'm writing a will, I don't include that child.
Yeah.
Then after I'm passing on, then the parent, the mother, decided to come on board and say, hey, Onkarabile Phela have a child with me. So the child need also to benefit because that is their father, right? Now, isn't it that the law also back up the child? Then we do the DNA test to prove that the child indeed is Onkarabile's. Is the law not going to back up the child even if it's not included in the will?
So so there's two types of you've touched on two type of law,
Okay.
right?
Okay.
So we have the interstate succession, we have the T-state succession, right? The T-state succession, it's when a person dies with a will, and whatever the person left behind, then it will be dealt with according to the will.
Okay.
So we read the will and we follow what the will says. That is T-state succession, right? And then we've got interstate succession. Interstate succession is when a person dies without a will. And then they will we have to follow the rules of interstate succession. And the interstate succession says that if you die without a will, whatever you had, it must go to your kids. Whether the kids are born in the marriage or outside the marriage, everybody will come and say, we were children of Onkarabile, we therefore are beneficiaries and heirs of Onkarabile. And then a master of the High Court will call a family meeting, and then they will distribute according to the interstate succession. However, if Onkarabile left a will and say to the will, I'm giving this to ABC, and decide that he's not giving a certain share to a certain child, then that cannot be contested. However, what can then happen is that they can go to the estate and sue on the estate of Onkarabile. Remember, there's that thing that when we grew up, right? We grew up in Soweto and we were told that when you die, your debts die with you. So it doesn't happen like that. So when you die, there is an estate. Okay. So your estate, then there will be claims against the estate. So when you die, you report it to the master, and then they will draft something called L&D account, liquidation and distribution account. In that, there are people who've got a claim against the estate. So I think this child would then come and claim against the estate. Okay. But if the will is clearly stating that asset A or asset B, asset A goes to Noluthando, asset B goes to Ntombi, then it's going to be shared according to the will. A will is just a powerful document. It speaks and it's straightforward. You follow what the will says.
Okay, we are about to go to a short break now, but let's just finish up with this question. Why is it, what you are saying now, I hear knowledge is very, very important. Why is it not common to black society to understand this kind of important information like drafting of will? Why is it that? Because we have a lot of fights, you know, after a certain individuals has deceased. Why is it that we are not really taking it into consideration?
Most of the time, as black South Africans, there's things that we consider it as a taboo. like to speak about your death while you're still
Yes,
alive.
exactly, yeah.
And even if, when I shout at my children, I tell them, guys, one day I will die.
Yes.
Mama, please don't say
Don't
that.
confess that. It's like
don't
you're
talk
confessing.
like that, So as young as they are, they don't want me to talk about me passing on. That, guys, one day I will die. You will have to stand up on your feet and do certain things. So I will not be here forever. So it comes as natural. So our black people, they take it as a taboo, but also there's lack of information that is distributed to our people. Our people don't have knowledge. They don't know these things. So I think it's very important as young professionals that we go out there. That is what we do. I'm not going to mention the name of the institution that I'm talking about. That we do road shows. We go to clinics like your Shawela clinic. We go there. We go to Bara. You go to halls and inform people that this is what needs to be done. Before you die, you need to draft a will, and it's not expensive. So people procrastinate even after they've had the information. They are aware that there must be a will. They still don't draft their wills, but what they do, they procrastinate. They will do it at the later stage. They think that it needs you to have a lot of money, and it doesn't. You don't have to have money for you to have a will, and you don't have to have a lot of assets for you to draft a will, but it's just important to have a will while you're still alive.
And I like the word taboo because I think it now brings something into my mind that religion also, I think it plays a role there, because there's this thing of negative confession and positive confession.
Yes.
Like when it talks about that, it's like now you are confessing bad thing, or you're confessing death upon yourself, but
of
only to
course.
find that the reality is you are gonna pass on one day. You're not gonna live forever.
Yes,
that's the reality.
That's true, yeah.
Yeah. So, but let's go for a short break. Then when we come back, we continue on this discussion. Ladies and gentlemen, we are just gonna take a short break. We will be back shortly. Stay tuned. Welcome back to On Writing with Onkarabile, a show that aims to promote reading and writing in the communities. We seek to restore pride and dignity of Africans through the power of reading and writing. And we are still having Advocate Ntombifuthi Mpofu is here to share more on drafting a will. Sister Ntombi, you spoke earlier about reading of a will. So I just want us to go in details on that. When we read out a will, who must be present during the reading out of a will? And why is it important to read out a will? Anyway.
Okay. When someone passes on, it's important that the will gets to the master of the High Court, right? And the people that must be present when the will is being read out, it will be, there's someone you call an executor, the person that has been appointed by a will. So a will has clauses, right?
Okay.
So in the will, there's a clause where the clause just deals with an executor who would read out the will. It's that person that actually reads out a will, right? Okay. So then, after it's being taken to the master, then the master will look at it. And if the master is satisfied, then the master will call a meeting to say, okay, you have been appointed as an executor of this will. Ntombi and Noluthando are the beneficiaries or heirs in this will. And then they will read out a will. So when the will is being read out, it's to eliminate confusion. If you have left a house to me, in the will it will say, Onkarabile has left Ntombi a house at 24 Dlamini Fox Lake. that house goes to Ntombi. And then a Ford Fiesta with registration number XYZ, it goes to Onkarabile. Then it avoids me thinking that Ntombi received a house. Just because Ntombi received a house, automatically I'm entitled to receive the car as well. Kanti, the only time you wanted me to inherit the house, not the car. You wanted me to inherit the Tupperware, not the makeup. Because we as people, we own different things, and we consider them as assets. Like the young ladies, they have your Tupperware, they've got their Avon makeup bag. So a person who is 16 years old can actually write and say, in my will, this is my will. I want to give my Adidas school bag to my friend. And then the person writes, whoever friend, I want to give my makeup bag to my aunt, and name the aunt. It's not only the houses, the cars, the monies, the insurance policies. No. It can be as simple as a school bag, as simple as a bag, as a frame. This photo frame, I want to give it to a certain person, and that thing has got a sentimental value.
So I want to know, let's say a will versus tradition now, right?
Yeah.
Traditionally, you'll find out that we grew up saying, okay, the house belonged to the last born.
Yeah.
They will just say that without writing down. and it will be like that without writing down.
Yeah.
Do you think it can be possible, the days that we are living in today, that it can still continue like that, where there is no will, or there must be a will? Or tradition can apply when it comes to that? If I did not leave a will, knowing that traditionally the house will belong to my last born.
Okay.
But then when it comes to the law, you spoke about the issue of the second type of the law. That says what my asset belongs to my kids, not a kid. But traditionally it says the last born, right? So do you think it will apply, or that's where the will be needed?
Okay. Firstly, when we are dealing with customary law, there's ways of dealing with our customs and our tradition, right? And it can be dealt with in a different way, shape, or form.
Okay.
So when we are speaking about, we observe the customary law, we observe the traditions, right? And we respect them, and we don't discard them, but we've got to follow the laws of the land, right? You remind me of a situation that I was in, I think 3 weeks back. I was approached by a gentleman. He came to me with a lobola letter. He says to me, listen here, Ntombi, my wife is saying to me, she's not married to me. But now, what does this letter mean? And I'm like, no, you are married to this person in community of property because of this letter, this lobola letter. Yeah. But you are not there. But I just want to tell you that our courts, they observe it. So you can actually take this lobola letter, you write, there's an expert application, you make an expert application, you ask the court to declare that lobola letter valid, and then the court will then tell the Minister of Home Affairs to issue a marriage certificate just because of that lobola letter. That is your traditional things for you. Yeah. But if you elect to die without a will, it limits you. It limits your. I always. It's called freedom of testation. When you die, when you die with a will, it allows you to still speak while you are dead. Your voice is no longer there, but your will is speaking for you, right? So it's very important that as a young professional, when you leave a will, you eliminate a lot of fights and confusion amongst the family members. There are people who are very, very very evil, I'll say, very, very evil, that they see that this person is employed by the municipality. They then volunteer, I want to raise Ntombi's children. You know why? Not because they want to care for the children, but because they see there is a benefit, there's money there. So if you die without a will, you are leaving your kids to be frustrated. So when you die without a will, it will be your estate will be administered in terms of interstate succession. So in interstate succession, we've got what we call arrows. The arrow will first go down. If there's nothing down, so down we are looking at your descendants. Your people will consider them as your children, right? The kid that you got with your girlfriend, you got out of your marriage, the kid that you got before you got married, those are your descendants. Those are the people that can benefit out of your will, your estate, not your will, your estate, right? And then if there is nothing, if the arrow that is facing down, there is nothing down there, then the arrow points up, it will go up. Who is up there when we're looking at the arrow? It's your parents, right? It's your mother, your father. Those are the people that we inherit. I'm just going to give you a scenario now. There's a case I'm dealing with that has got the same thing about the arrows. And then if there's nothing up there, there's no dad, there's no mom, then it goes sideways. Where sideways? So it can either be your brother, your sister. If there's no brother, there's no sister, the arrow goes further aside, which is relatives. Your cousins, your relatives, and whoever. So now in this scenario, there was a family. This family, the mom got a house back then. In the old times, they said in Tembisa, you cannot, as a woman, a black woman will not own a house. So there were houses. There's something that when you go to deeds office, there's something that a title deed will be written T on top, and then there's another deed titles that are written TL, right? So the TL stands for title lease. So the title leases were not given to black women. So in this case, the lady had 2 children. Ugogo had 2 children. She had A, which was a boy, and B, which was a girl. She stayed in this house, and the government gave her this house, but the house was not in her name. And then it was then registered under A. Why A? Because A was a black male. So the A inherited the house in Tembisa. And then A passed on. But before A could pass on, A had a child. And we're going to call this child C. Had a child which is C. When Gogo realized that my son has passed on, then it means my daughter B will not benefit anything.
Going through the son.
And I do not like C, you know? It happens that the Gogos don't love their girl children. They don't like their grandchildren, you know? The boys one, right? So then she then decided to go to the master of the High Court and said, Master, my child never had a child. He passed on. And then now the master said, okay, I'm going to appoint you as an executor of the estate. Then fast forward, the C then discovered that no, my father passed on. There was a house in my father's name. So the house, what are the rules? The rules, the arrow says it goes down. So what are the rules? The rules are saying that C must inherit
the house.
Actually, C must inherit the house. So then C then approaches the master of the High Court to say, Master, I'm actually the right descendant. I am the beneficiary of the estate, and I am supposed to be an executor of the estate. And the master then scratched out the one that was given to Granny, and then they then appointed her as the new executor.
Oh, but now what about the girl child?
So the girl child, the thing is now, what then the court? So the family is supposed to take the matter to the High Court. It has to be decided at the High Court level. So what will happen to the girl child? So the previous laws actually disinherited the girl children. They didn't consider the girl children. Only the male children will benefit out of the estate. So they got disinherited by the apartheid laws. But now she's got to approach the courts and say, court, please assist.
Yeah.
So if the court intervenes and she can prove that, listen, this house belonged to my mother and my mother was the rightful owner. The only thing is that because of the law of the land at the time, she could not, then the property should not be placed in her name. Then the court will then go back to interstate succession and look at it and be like, okay, if Gogo had 2 children, the arrow will go down. A will get 50% of the house,
exactly.
and B will get 50%
Yes.
of the child, of the share. Now, if B had a child, had 2 children, the 50% would be divided by 2, and then the other one will get 25 and the other one will get 25. So it will go like that, and then it goes down. If the B has 3 children, it will be divided according to 3 children. If A had 2 children, it will be divided by her children. So in our scenario with Gogo, what needs to happen is that B, who's a female child, must approach the court and tell the court, listen, this is what transpired here.
Yeah.
And then the court will say, okay, in as much as your brother, your mom is dead and your brother is no more there, but your brother had a child who's C. So the share of your brother goes to his child and you still have your 50% share.
We are going to go for our second and last short break. But before that, I just want to ask a quick question.
Yeah.
If the arrow doesn't, point down,
Yeah.
doesn't point up, doesn't point on the sides,
Yeah.
where is the estate going or the asset going?
It gets forfeited to the state,
Okay.
unfortunately. So if the arrow goes down, finds nothing, goes up, finds nothing, finds sideways, there's nothing. It stays there, and then after some time, I'm not sure of the period, after some time, then it gets forfeited back to the state.
But you can write a will. Let's say we have no arrows. You can write a will and maybe donate to a certain charity if you know that you don't have arrows. Is that going to be accepted? Maybe.
So I spoke of interstate succession wherein there is no will. I also spoke of state succession where there is a will. So where there is a will, a person can actually write a will and say, I donate my entire estate to SPCA.
Oh, okay.
And then it then goes to SPCA.
Okay.
So that's the situation. But with the arrows, there's no will. So we have to deal with it using the arrows. If we can't find anything down, we go up or sideways.
Thank you so much for such knowledge. Let's continue after a short break.
Thank you
Ladies and gentlemen, we will be back shortly. Stay tuned.
The Creative Corner with Nolu Knowles, a cozy and inspiring show that features interviews with artists, showcases their work, challenges, and successes. Every Tuesday at 2 p.m. only on Share Radio. Tune in live on Facebook, YouTube, and TikTok. This is Share Radio.
Welcome back to On Writing with Onkarabile, a show that aims to promote reading and writing in the communities. Please don't forget to subscribe, to share online, and we are still having advocate and Ntombifuthi Mpofu, who is here to share more on drafting of a will. We spoke a lot, advocate, before we went for break. But in front of me here, I have what we call a joint will, you know, which I want us just to elaborate a little bit. What is a joint will? The difference between a joint will and a will that is done by one person. If maybe you can just elaborate a little bit.
Okay, so we've got 2. I would say for now we are discussing the will, which is done by one person, which that person we call that person a testator. And then we've got a joint will. A joint will happens when two people, like for example in our scenario, the will that is before you, it's a joint will of two people. These two people, they are married to each other in community of property. So you have a wife and a husband, and they jointly own a certain asset. I would call it an asset. So they have a house jointly. Jointly, they have a car, right? It belongs to a joint estate, right? And they have kids that they have jointly, right? But now when they pass on, they foresee that if we leave this earth without writing a will, our children will fight amongst each other. Remember, we are Africans. There's that rule you spoke about. I've never heard of a last-born child having an automatic right of inheriting a house. But this is the first time I hear it. But where I come from, it is about the boy child, right? The boy child gets to automatically they inherit. We grew up knowing that the boy child will inherit the house. The girls must go out.
No,
there.
you mean the one I'm talking about is the boy child, but the last born.
Okay.
Yeah.
So they go out. The ladies. If you've got 4 kids, it means now the 2 boys will remain at home, and this is their house, and the 2 girls must then go out there, fend for themselves, and they must just get married, and they not form part of this joint estate, right? But now these 2 parents have decided jointly to say, no, we are going to advocate Ntombi. We do not want our children to fight. We do not want to leave the confusion with our families to decide what must happen when we are no longer here. So what they do in this joint will, they will tell you, firstly, you have to identify what assets do you have and what do you want who must get what. So in our scenario, we have the couple, they have a house. They are saying, this house, if the husband passed on before me, the wife, then my husband will not sell this house. The house will be an usufruct. He will get to enjoy the house. He stays in the house. He doesn't have to sell the house. If there's rooms at the back of the house, he can still collect rent and live off the fruits of this house, right? But he doesn't have to sell the house. And the house now belongs to, because now I'm no longer there, the house now belongs to my 4 children, which is, they will name the children that, because we've got 100% in this house, right? And then 25% will go to the first child, second child. But there is a condition in this house. The condition is that the house should not be sold. That 25% should not be sold to anybody. You can use it, but if you do not want to, if you say, I want my 25%, we can't sell it. It's not for sale. It's either you come, you stay here, and that's it. If you don't want it, you can then repudiate. Be like, okay, I don't want my 25%. And then after that, the 4 children, another clause that is in this will that is before you is that this house that we are talking about does not form part of any marriage regime. Remember, if someone gets married to somebody, those people, if they get married in community of property, they inherit from each other. They inherit the dads, they inherit the things. But now, if there is an asset that belongs to somebody, then this person will actually inherit. So it is excluded. You cannot inherit. It can't form part of the marital regime.
Okay.
Yes.
All right. No, it's very, very informative. And like, let's say 2 people. So you have to agree with everything if you are doing joint will. right? There's no way that maybe you have favoritism. Me, I favor this one, I don't favor this one. Because it's a joint will. Then it must be like equal.
Yeah. So a joint will, it's more of, when you are married and you are married in community, you take a step of getting married and you get married in community of property. Then your marriage regime is then treated as in community of property. 50% of everything that you own, it automatically is 50%. So it's 50-50, right? If you've got 50% of the debts, it falls on the other spouse. If you've got 50% of the assets, it's a joint thing. So if we decide jointly that we have to agree that this is what we want to do. If you pass on, I leave this for you, you can, then the children will get this out of this. Because now, what does it do? It actually, because now, as Africans, we grow, we are family based, we are community based, right? There is family members from the wife's side, there's family members from the husband's side, right? Then they will come and be like, okay, if there's minor children, they will come and be like, I want to take care of the children. I want to come and stay here in my sister's house, right?
Yeah.
And then, but if the sister has made a decision that no, Auntie Z must not come and stay in my house, but Auntie A must come and stay in the house, and then Auntie A will decide, I don't want this, and then maybe there's an alternative that, okay, if this one does not want to take care of the kids, this person will be then in charge of taking care of the kids. And also, this thing about having a joint will is that when the parties, remember if you have a property, it is registered on both your names. If you pass on, then the other party becomes the sole owner of the property. Now, if you pass on it, you must actually know who could. If this person passes on, then who must be responsible to take care of the house, right? For example, in our house, if we can go out here, we go knock from house to house. If you find that the initial owners, they are no longer there, but there is no one who's saying, I'm raising my hand, I will be in charge of paying the rates and taxes. But the dustbin on Wednesday, the pick it up comes on Wednesday to collect, and it's a responsibility of the family members to report the estate so that we will know who will pay for the municipal fees, So those things we get to neglect them, but we will get it right as we go and we give information to our people.
Last question, Sis Ntombi. Unfortunately, time is not on our side. You wanted us to avoid this question, but we then have to talk about it.
Yeah.
The difference between a will and a contract. Is there a difference between a will and a contract? If there is a difference, then it means you will have to owe us another visitation to come. Yeah. And now we talk about contracts. If there is a difference, because people need to know more about contracts. So what is the difference between a will and a contract?
I'll definitely show. I will come back and discuss the contracts.
Okay.
On the topic contracts alone.
All right. Okay.
But I can tell you now.
Yeah, just
there
briefly.
is a huge difference between a will and a contract. A will deals with the wishes of the deceased or a testator. What do you want to happen to your asset, your estate, should you pass on?
Okay.
So it states what must happen.
Yeah.
It's not a contract.
Straight and forward.
It's your wish. It's your wishes. It's the wishes of the dead person. It's how they wish. But a contract. So it's a topic for a whole day. I can promise you.
No, we'll make time.
It's a topic for a whole day, because there are contracts that that are written. They are verbal contracts. They are contracts that you enter them by implication, right? Let's go to a contract that you enter by implication, right? You go to a car wash to wash your car. There is a board there. It says to you, welcome to Onkarabile a car wash, right? And down there is words that say we are not responsible for any damages, loss, or whatever that happens to your car. And you still drive your car and you leave your car. After reading that, you have by implication, you have entered into a contract.
Let's put a pause and then we make time. It's very interesting. We make time, then you come and we talk about contracts.
Yeah, contracts needs the whole day.
Yeah,
because there's implication, there's written, there's verbal.
Yeah, no, definitely.
And you have got to define what is a contract. What are the clauses? Who qualifies for a contract? When can you execute the contract? When can you cancel the contract? There's a lot.
Because even when it comes to employment sector, we still have an issue about the contracts.
Yes.
An employee doesn't know what is the contract saying.
Yeah.
So people really need to know more about it.
Yeah.
But so, let's put a pause, please.
Yes. We'll make time.
Thank you so much for coming to our show. And then if people want to maybe consult you, can they get hold of you? Are you on social media or something when people maybe want to get your services and to know more about drafting a will? Can they get hold of you?
Unfortunately, I'm not on social media. But I have a contact number where people can call me. I've got an email address where people can write an email to me.
Can you share?
Okay, my phone number is 072-627-8273. I repeat it, 072-627-8273. And my email address, it's N for November, P for Papa, 55, M for Mike, P for Papa, O for October, F for Future, U for University, @gmail.com. So it's np55mpofu@gmail.com.
Okay. All right. Thank you so much for your time. Then we'll see you soon when it comes to the issue of contracts. We'll then make time. We'll talk about the contracts.
Thank you so much for having me.
You're welcome. Ladies and gentlemen, we have come to the end of our show. That was Advocate Ntombifuthi Mpofu. She will be back again. Just stay tuned. And don't forget to subscribe, to share online as we are wrapping up our conversation. Thank you so much for being with us today.